All right, let's dive into a fascinating legal battle. It's one homeowner versus his entire neighborhood association. And it's a classic story of an individual's dream hitting that solid wall of community rules. And it all kicked off with a pretty simple plan to just upgrade a home. So let me ask you this right up front. Can your HOA actually legally stop you from moving into a home that you've already bought and paid for? As we're about to find out, the answer is, well, it's a lot more complicated and, for this one family, way more devastating than you'd probably think. This is a true story. We're talking about Mr. W. Douglas Stickler and his fight with the Orange Grove Mobile Estates Homeowners Association. We're going to really unpack the actual legal case here to see exactly what went so wrong, and more importantly, what it means for anyone living under these kinds of community rules. Okay, so picture this. Our story starts back in 2006. Mr. Stickler and his wife, they're living in this 30-year-old mobile home. And frankly, it had seen better days. We're talking water damage, termite damage, even structural problems. They decided, you know what? It's time for a replacement. A simple enough plan, right? Or so they thought. Here's where things get messy. The problem, the entire reason this whole dispute happened, wasn't about the new home itself. No, it was all about which set of rules Mr. Stickler was supposed to follow. Because, as it turns out, the community had two completely different rulebooks written years apart. So let's look at the timeline. The community's original rules, they were written way back in 1971. But then, in 1987, the HOA enacted a brand new set of restrictions, and they believed these new rules completely replaced the old ones. This one change is what set the stage for a massive conflict that would finally blow up almost 20 years later. And here it is. This is the critical difference. The original 1971 rules had zero age limit on replacement homes. But the new 1987 rules, whoa, they introduced a huge new restriction. Any new mobile home brought in had to be 5 years old or newer. This one single change is the pivot point for this entire story. So Mr. Stickler finds a replacement home he and his wife can actually afford. Problem is, it's 11 years old. He submits his request for approval, probably thinking it's just a formality. And that is when his simple plan hits a massive roadblock. And this all happened incredibly fast. On June 29th, Mr. Stickler sends in his request. Just 1 week later, 1 week, on July 6th, the HOA's committee denies it. The reason was blunt. His new home was 11 years old, way older than the 5-year limit in that 1987 rulebook. The very next day, Mr. Stickler wrote a letter back to the HOA, and man, you can just feel the desperation. He explains that they are in a terrible spot, that they could literally be homeless because, and this is so important, they had already spent most of their savings on the new home. So he formally requested a hardship waiver, and he really laid out his case. He told them about the financial bind they were in, his family's medical bills, and the fact that his current home was basically becoming unlivable. He was, in essence, pleading with the committee to just make an exception for them. But when that emotional plea for a hardship waiver just didn't work, Mr. Stickler's strategy had to change. He shifted from this personal appeal to a legal one, and he started digging deep into the language of the HOA documents themselves. And here's his argument. He believed there was some language in the 1987 rules that essentially grandfathered him in. He claimed this meant he had what are called accrued rights from the original 1971 declaration, and specifically the right to install a mobile home of any age he wanted. So you got these two totally competing interpretations. Mr. Stickler is saying, hey, accrued rights means I get to keep my right from 1971 forever. But the HOA, they countered, saying, no. Accrued rights just meant that back in 1987, you didn't have to tear down the home you already had. It was a shield for the past, not a sword for the future. Well, with both sides completely dug in, the case eventually landed in front of an administrative law judge for a final binding decision. So, what did the judge have to say about all this? The first and really the most fundamental ruling was this. The 1987 declaration was the law of the land for that community. The judge found that it had officially and legally superseded, or replaced, the old 1971 rules for everybody. And that included Mr. Stickler. Now, that key legal word here is supersede. All it means is to take the place of something, to replace an old rule with a new one. The judge basically confirmed that when a majority of homeowners voted for the new rules back in '87, they were all agreeing to throw out the old ones entirely. So, it follows that the judge completely rejected the accrued rights argument. The ruling pointed out that if Mr. Stickler's interpretation was correct, well, then the 1987 rules would be totally meaningless for all the original homeowners, which obviously wasn't the point of the new rules. Okay, but what about the plea for hardship, the personal situation? The judge ruled on that too, finding that the HOA did not abuse its power when it denied his request for a waiver. They were acting completely within the rights given to them by the community's own rules. So why? Why did the judge side with the HOA? Well, it came down to a few critical points. First, the HOA had been applying this 5-year rule consistently with everyone. Second, the rules clearly state waivers are at the committee's sole discretion, which is a fancy way of saying they have the right to say no. And third, and this one is a huge one, Mr. Stickler put the cart before the horse. He bought the new home before he got written approval, which was a violation of both the old rules and the new ones. And so the final verdict was completely unambiguous. Mr. Stickler's petition was denied. After all the letters, all the arguments, all the legal back and forth, he lost his case. What a tough story, but it is also an incredibly powerful case study. So let's zoom out for a minute and ask the most important question. What are the practical, crucial lessons that we can all take away from Mr. Stickler's experience? And this really boils down to 3 absolutely critical takeaways for any homeowner. First, always read the current rules. Don't ever assume the rules you moved in with are still in effect. Second, get approval in writing first. Never, ever spend a single dollar before you have that green light. This was Mr. Stickler's biggest misstep. And finally, you have to understand what discretion means. A hardship waiver is a request, not a right. The board can almost always say no. In the end, this case really highlights that fundamental tension of living in a planned community. It's this constant balancing act. So I'll just leave you with this thought to chew on. Where exactly does a homeowner's personal right end and the community's right to set the rules for everyone begin?